Hello, everyone, and thank you for attending today's webinar, New Year, New Laws, a look into the employment law landscape for 2023. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. I will try to answer these during the webcast, but if a fuller answer is needed or we run out of time, I'll answer it later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. This webinar is CLE accredited in California, Illinois, and Texas for 0.75 hours of general CLE credit, and in Missouri for 1 hour of general CLE credit. The webinar is also CLE accredited in New York for 1 hour of experience and transition credit. We award CLE based on attendance for the entire 50 minutes. Due to changes in jurisdictional requirements, you will notice that we are no longer using automated pop-up attendance checks. As required, we will display secret words in multiple choice polls during the webinar. You will be required to select today's secret word from a multiple choice list. Please respond to these polls to demonstrate your continued engagement and to earn your full CLE credit. We value your opinions and appreciate your participation in this course. So first of all, I wanted to take a moment to introduce myself. My name is Susan Lorenc. I'm a partner in our Chicago Labor and Employment Department. My contact information is on the screen, so if anyone has any additional questions after you've heard today's presentation or on anything unrelated even to the topics of today's conversation, please do not hesitate to reach out. I would be happy to talk further to any of you. I also wanted to start by going over our agenda for today. In all honesty and in full transparency, we're going to talk about a lot of different laws that either went into effect late 2022 or at the beginning of 2023 around the country, both state and federally, which is not to say we'll be able to cover all employment-related laws that went into effect, but rather I'm treating this as sort of a high-level assessment of what I believe are the biggest changes that we should all be aware of. We're going to cover a lot of them without going into as great a detail as any one of these deserves, so please do not hesitate to reach out if you have any more detailed fact-specific questions. You'll also hear me say throughout the course of today's seminar that there are aspects of each of these laws that we don't know the full landscape of. We don't have regulations, for example, on some of these laws. So a lot of these are still to be determined and how they will be applied to our day-to-day lives and how courts will interpret them. But I more want to give you all an opportunity to issue spot as things are coming up, and then to think about what you're doing with your current employees, where you have different employees, where you may not want to recruit new employees, and make all of us a little bit better versed in what's gone on in the last several months. So with that caveat, I wanted to cover these 4 general topics with a nice little potpourri at the end. We'll discuss non-compete and non-disclosure laws. We'll discuss wage and hour laws that have gone into effect. We'll cover some new leave laws that either went into effect or are going to go into effect. And then we're going to tackle a few miscellaneous state laws of interest. But before we dig in, I did want to make everyone aware that today's CLE is part of a larger program that has been developed by the Thompson Coburn Labor and Employment Group. We will be coming to you on a monthly basis with a different topic for a webinar like today's. So we hope that you will become a regular attendee and will start to put us into your calendar on a monthly basis and learn throughout the course of the year all sorts of different things that you may be tackling as attorneys and HR professionals. So with that let's start with non-compete and non-disclosure laws. As many of you probably saw, the U.S. Federal Trade Commission, which enforces antitrust statutes, recently announced a sweeping new proposed rule that, if promulgated, would ban nearly all post-employment covenants not to compete between employers and employees. The proposed rule would not only prohibit future non-compete agreements, but would also invalidate those already in effect. Specifically, the FTC proposes prohibiting employers from entering into non-compete agreements with workers on or after the effective date of the rule, and it would ban requiring employers, it would also require employers to take affirmative steps to formally rescind non-compete agreements by sending notice to affected employees. The rule proposes only a very limited exception, permitting certain non-compete agreements between a seller and a buyer of a business where the restricted party holds at least a 25% ownership interest in the business. Although the proposed rule does not purport to prohibit the use of other restrictive covenants, such as non-disclosure agreements, non-solicitation agreements, and no poaching agreements, those agreements may be considered a non-compete clause within the defined terms of the rule if they are so unusually broad in scope that they function as such. Now, this is definitely an evolving conversation. The proposed rule is in a notice period where people and companies can make comments to the proposal of the FTC. It's certainly left to be seen if this will actually go into effect. It's also left to be seen if the FTC has the jurisdiction to do that. We did know that President Biden last year indicated that he'd asked the FTC to look into this and to take the appropriate steps. So we believe that the White House does support this effort, but a lot to still be parsed out as to what ultimately is entered into the rules of the FTC and if we have any regulations around what that means. So more to come on that. Rest assured, we are keeping our eyes peeled on that, and we'll update you all as we get more information. But there's nothing unique about the fact that the FTC is looking at this. We already know that many states have taken a strong stance on non-competes in recent years. We have several states already that already ban non-competes with very narrow exceptions, and that includes California, North Dakota, and Oklahoma. There are also 9 other states that prohibit non-compete agreements unless the worker earns above a certain level of compensation. For example, Washington, D.C.'s 2022 law that went into effect on October 1st requires that non-competes are prohibited in newly signed employment agreements. An amendment was passed over this summer that provides some additional nuances to this ban. Pursuant to the amendment, the ban now only applies to District of Columbia non-physician employees earning $150,000 or less annually. In other words, non-physician employees earning more than $150,000 may still be subject to the new non-compete provisions. And I'm calling out specifically non-physicians because there are specific rules around physicians that for the purposes of today's CLE we will not get into. Certainly if you have physicians in your workforce, do not hesitate to reach out if you need additional information on Washington, D.C.'s provision. But bottom line, be cognizant of that salary threshold of $150,000 if you have employees in Washington, D.C. A similar law went into effect on January 1 of 2022 in Illinois. That law says that employers cannot enter into enforceable non-compete agreements with Illinois employees who have expected earnings less than $75,000. And similarly, we cannot enter into enforceable non-solicitation agreements of either customers or employees with Illinois employees who have expected earnings of less than $45,000. I should note that that 75 and 45 threshold goes up in $5,000 increments over several years, and we have guidance on that through 2035, at which point the legislature will have to take a look at that salary threshold and determine whether it's reasonable or if it needs to be changed. And I would also point out the concept of expected earnings is actually quite broad. It encompasses things like commissions, bonuses, other benefits. So we need to really be mindful of exploring whether we have a reasonable basis for believing that employees have expected earnings in excess of either 75 or 45,000, and if we can defend that, especially if someone ultimately does not end up meeting that expectation and makes less than that amount. The Illinois law also indicates that the non-competition or non-solicitation agreement must be supported by independent adequate consideration. The definition of adequate consideration in the Illinois law is that the employee worked for the employer for at least 2 years after the employee signed the agreement containing the covenant, or the employer otherwise provided consideration adequate to support an agreement to not compete or solicit, such as a period of employment plus additional professional or financial benefits, or merely professional or financial benefits. That's all a very nice way of saying our general advice has been that if you have an individual in Illinois that you'd like to sign an agreement, we really are suggesting that they be given a signing bonus that's tied directly to the restrictive covenant. So you'll see in our agreements that the concept of the signing bonus will be right before the non-compete section, as opposed to just embedded in the employment agreement itself. I'm sure your next question is, well, how much of a signing bonus? And if only the Illinois legislature had been that helpful in its drafting. The short answer is I don't know. The better answer is it should bear some relation to the employee. So if you have an employee who's making $75,000, a $500 or $1,000 signing bonus, or the equivalent of 2 weeks of their salary, is probably reasonable. If someone makes $500,000, I would argue that that $500 signing bonus is maybe de minimis and would not be seen as reasonable compensation. We are keeping our eyes peeled on court filings to see if there's any guidance from the court as to what's going to be considered quote unquote adequate. But the long and the short of it is, if someone quits or gets fired within 2 years of signing the non-compete, and they weren't giving a signing bonus as part of it, we are going to have a really hard time overcoming the consideration aspect. And then the other piece to the Illinois law is that employers are required to provide Illinois employees 14 days to review a non-competition or non-solicitation agreement, and we must advise them in writing at the same time to consult an attorney before signing it. So while this went into effect in 2022, I just want to make sure everyone's on the same page as to what is in effect now. It's important to note also that that law was not retroactive. So if you had someone that signed something prior to January 1 of 22 that did not otherwise comply with these requirements, you're fine. You don't have to go back and look at it. That is a distinction between the FTC proposed rule and Illinois' rule. The FTC's proposed rule is retroactive and would invalidate essentially all non-competes. Colorado dipped its toes into this as well, and its legislature passed one of the nation's newest laws that went into effect on August 10th of 2022. Although the law makes clear that reasonable confidentiality agreements between employers and employees are still perfectly legal, the law severely restricts the utilization of non-compete and non-solicitation agreements, except where they are required to protect trade secrets as specifically defined under the state law. Under this new law, non-compete agreements are unenforceable unless they accompany the sale of a business or involve an employee who earns more than $101,250 annually. Additionally, non-solicitation agreements are invalid unless they involve employees making more than $60,750 annually. Colorado employers must notify job applicants about non-compete agreements and allow them to review the agreements before they accept any job offers. If employers wish to impose non-compete agreements on current employees, they must provide written notice to the employees at least 14 days before the agreement goes into effect. Non-compliance with this Colorado law has severe consequences for employers in that they can face penalties of up to $5,000 per worker. Violation of the law can also lead to Class 2 misdemeanor criminal charges, which carry a potential penalty of up to 120 days of incarceration and a $750 fine. I can honestly tell you in my 22 years of practice, I've never had to bail out a client, so let's hope we don't start dealing in that space in Colorado. Along those same lines of the penalties, in Illinois, it could invalidate the entire agreement, not just the non-compete clause, if we violate any of these. So the bottom line is these states that are approaching this area of law are really trying to put some teeth into it. So we do need to take these seriously and make sure that if you have employees across the country, we resist the temptation of a one-size-fits-all non-compete, and that we really look at it on a state-by-state basis. This issue is becoming even more prevalent post-pandemic, where our employees in many regards are all over the country now. They moved when they only had to work from home, and we might not even fully appreciate where they are. We need to dig into that and make sure that any agreement we're asking them to sign doesn't just comport with where they used to live, but also comports with where they actually live. So in addition to the non-compete concept, we also are seeing some movement in the non-disclosure piece. This is continued fallout from the Me Too movement. We've seen several states, including Illinois, really tackle non-disclosure agreements in the sexual harassment space when we're dealing with separation of employment. But here, the feds decided to take a different approach, and they passed the Speak Out Act, which prohibits judicial enforcement of non-disclosure and non-disparagement clauses with respect to sexual harassment and sexual assault disputes when the clause was entered into before the dispute arose. This applies to claims filed on or after December 7th of 2022. Specifically under the Act, a non-disclosure clause is unenforceable if it was entered into before a dispute alleging sexual harassment or sexual assault under federal, state, or tribal law, and requires the parties not to disclose or discuss the conduct, a settlement involving the conduct, or information covered by the terms and conditions of the contract or agreement. And it covers a non-disparagement clause and states that it's unenforceable if it was entered into before a dispute arose, and requires one or more parties not to make a negative statement about another party that relates to the contract, agreement, claim, or case. The Act does not specify the types of agreements to which it applies, though. However, it does contain a statement of congressional findings which states, among other things, that non-disclosure and non-disparagement provisions in agreements with, quote, current, former, and prospective employees and independent contractors can perpetuate illegal sexual harassment and sexual assault by silencing survivors and others who know of such conduct. So to that, employers should assume that the Act covers all such agreements, again, the pre-dispute type of agreements. That said, it does not limit the use of non-disclosure or non-discrimination or non-disparagement clauses in agreements, such as a separation or settlement agreement entered into after a dispute concerning sexual harassment or sexual assault arises. It also expressly excludes from its reach protections for employer trade secrets and other proprietary information. I will say anecdotally that this act, while eye-opening on its face, doesn't really do a whole heck of a lot in my experience, because it's very rare that we see these types of clauses in employment agreements themselves, if for no other reason than, as most lawyers will appreciate, you typically can't release a claim that doesn't occur, and you can't ask someone not to talk about a claim that doesn't yet occur. It just sort of stands to reason. So for the feds to mandate this doesn't really move the needle, in my opinion. But to the extent anyone does have employment agreements, or executive employment agreements in particular, that contains this kind of pre-dispute language, we really need to be mindful of the reach of the Speak Out Act and make appropriate revisions so that we're not inadvertently impacting those kind of trade secret and other confidentiality provisions that are more typical in employment agreements. So with that, I'm now going to move on to new wage laws that we've seen sprout up. First, we're going to talk about California's expanded pay data reporting and mandatory pay scale disclosures. This bill requires private employers with 100 or more employees to submit a pay data report to the California Civil Rights Department annually on or before the second Wednesday of May, beginning May 10th, 2023. The pay data report is separate from an employer's EEO-1 report and must include the median and mean hourly rate for each combination of race, ethnicity, and sex within each job category. Additionally, beginning Jan 1 of 2023, employers with 15 or more employees and at least one employee in California must include the pay scale for a position in any job posting. Employers must also provide an employee with the pay scale for the employee's current position upon the employee's request. Under this act, the term pay scale only requires disclosure of the salary or hourly range the employer reasonably expects to pay for the position, and not other types of compensation or benefits. So not about bonuses or commissions or vacation or health insurance or the like. But the pay scale must include piece rate or commission wages if that is reasonably expected for this position. An employer must include the pay scale in job posting for roles that may be filled in California, either in person or remotely. This is an increasing issue for employers. We saw this in Colorado, and I'll talk about that in a bit. But if you are posting for a role that is going to be at least in large part remote, which means a person, an applicant, could be in California, we have to now be cognizant of this pay scale requirement for all those job postings. An employer may not link to the salary range in an electronic posting or include a QR code in a paper posting that will take an applicant to the salary information. It must be stated in the posting itself. An employer must keep records of a job title and wage rate history for each employee throughout their employment, plus 3 years after. The record must be open to inspection by the California Labor Commissioner to determine whether there is still a pattern of wage discrepancy. And pay transparency violations may be subject to civil penalties of no less than $100 and no more than $10,000 per violation. So we don't know exactly what per violation means. Is that going to be each applicant? Is that going to be each person that clicks? Bottom line, this could get expensive quickly. Briefly, I want to cover New York and the other states. New York's does not go into effect until September 17th of 2023. The new law requires that virtually every job, promotion, or internal transfer opportunity that is advertised by a New York business include the compensation or range of compensation That is defined as the minimum and maximum annual salary or hourly range of compensation for a job. The law also requires that such advertisement include the job description for the corresponding job, whether that's the job, the promotion, or the transfer opportunity. This is a requirement that is not included in most of the other wage transparency laws that have previously been adopted nationwide. So we need to be real mindful of that in New York. Again, this is in particularly important for remote roles where the person just may happen to apply and reside in New York. Beyond the above, the law also includes provisions providing separate rules for job advertisement for roles that are paid solely on a commission basis. It also bars retaliation against individuals who exercise their rights and imposes additional record-keeping requirements on employers. Washington State's Equal Pay and Opportunities Act requires employees with 15 or more employees to disclose in each posting for each job opening the wage scale or salary range. Notably, the Washington legislation also requires employers to provide a general description of all the benefits and other compensation to be offered. So their law is even more nuanced. A posting under Washington law is defined as any solicitation intended to recruit job applications for a specific available position, including recruitment done directly by an employer or indirectly through a third party. So need to be thinking very, very broadly about the way in which Washington's law applies. Rhode Island's Pay Equity Act was amended to impose new pay transparency requirements. Unlike California and Washington's laws, the Rhode Island law does not expressly require employers to post anticipated salary ranges and postings, though. Instead, it provides that upon request, employers must provide that kind of range, and that employers should disclose the range prior to discussing compensation for the post with the application. However, even if not requested, employers shall provide an employee the wide range for their position, both at time of hire and when the employee moves into a new position. Further, employers must provide a wide range for an employee's current position at their request at any time during the course of their employment. So Rhode Island takes a different approach between applicants and employees and gives employers a little bit more leeway when we're just talking about applicants, less leeway when we're talking about current employees. And then briefly, Colorado was really the trailblazer on this. Their law went into effect on Jan 1 of 21, and requires that we disclose hourly or salary compensation or a range of compensation and a general description of all of the benefits and other compensations in all job postings, including promotions. So again, be mindful of where you are. If you are limiting your applicants to a specific state, great, then we need to be thinking about those states. But we have to be thinking much more broadly if these are going to be remote-only roles. Also be aware that there's legislature currently pending in Massachusetts and South Carolina that we're monitoring, and we'll update you when those laws go into effect. And then just real briefly, as I'm sure you all know, there are many states where minimum wage laws went into effect or where increases went into effect as of January 1. Several states, their minimum wages went up by more than $1. So make sure that if you have hourly employees, you are complying with those new minimum wage rates, including if you are forced to pay out accrued unused vacation of a separating employee, we need to ensure that they're being paid at the correct rate of pay. So now we're at today's first secret word. Today's first secret word is expand. Please select the correct word below, and I will give everyone some time to do that. Again, the word is expand. Just giving everyone a couple more seconds. I see that we're still waiting on some people. Okay, great. We will now move on to talking about some new leave laws that went into effect. In January of 2023, Illinois' Family Bereavement Act took effect. Illinois renamed its Child Bereavement Leave Act to the Family Bereavement Leave Act and expanded its scope to now require employees with 50 or more employees to give their workers up to 2 weeks of paid bereavement leave for more family members. Starting this month, covered family members that are included in this act include stepchildren, spouses, domestic partners, siblings, parents, and a spouse's parents, a spouse's grandparents, as well as grandchildren and step-parents. So suffice it to say, it is a very wide-ranging law, and if you have an employee who is electing to take this leave for a family member that you're not sure as to whether they cover, please reach out, because I fear that for the most part, we're going to come back to you and say, yes, that is a covered family member. The other piece that's important to note about this leave is that it also provides protected leave for reasons such as miscarriage, failed adoptions, or other unsuccessful productive and fertility procedures. So it's not limited to deaths of family members, but is also encompassing other fertility-related issues and reproductive issues. I also wanted to highlight, while we're talking about Illinois, something that we just very recently became aware of. It does not go into effect until 2024, but the Illinois legislature recently passed Paid Leave for All Workers Act, which file this under annoying acronyms that HR employment lawyers have to use. This is the PLFAW. I refuse to call it the PLFAW Act, but I have a feeling we're all going to be hearing that from time to time. This act will be providing coverage to nearly all Illinois workers with a minimum of 40 hours of paid leave or a pro rata number of hours during a designated 12-month period. Now, I should say before I get too deep into this, we know very, very little about how this is all going to work. We don't have any regs from the Illinois Department of Labor. So before you start, typing out a flurry of questions, please know that we are monitoring this very closely and will be updating everyone, especially as we get closer to its effective date of January 1 of 2024. But with that in mind, this act allows employers to choose to either front load the leave on the first day of employment or the first day of a designated 12-month period, or it does allow employers to use an accrual method. Under the act, leave accrues at the rate of 1 hour of paid leave for every 40 hours worked. The law will deem exempt employees to have worked 40 hours in each work week for purposes of the act's accrual, unless their regular work weeks are less than 40 hours. Once enacted in January of 2024, the law will permit employees to use the leave after 90 days on the job, unless an employer allows them to utilize it earlier. Employees may determine how much leave to use, but employers may set a reasonable minimum of increment of no less than 2 hours per day. The law will not require employees to give a reason for taking the leave, and employers will not be permitted to require any documentation or certification of the need to take the leave. Employers may require up to 7 calendar days of notice of foreseeable leave if they have a written policy provided to employees outlining notice requirements and procedures. However, if the leave is not foreseeable, employees must provide notice as soon as practicable. Accrued unused PLFAW leave will carry over annually, but the employer may not be required to provide more than 40 hours of paid leave for an employee in that designated 12-month period. Employers that choose to front-load the 40 hours, though, will not be required to allow for any carryover of unused paid leave to the next 12-month period. Now, this next piece is where there's a lot of confusion in my mind, because while the Illinois Wage Payment and Collection Act requires employers to pay out accrued unused vacation time at the end of the employment relationship, this act expressly states that employers will not need to pay unused paid leave at the end of the benefit year or at any other time, provided the employee has not credited the PLFAW Act leave to an employee's paid time off bank or employee vacation account. I have read that sentence and that piece over and over again, and I still don't know what exactly it means. I'm sure there's a lot of you saying, well, shoot, should we just get rid of our PTO program and only offer this because we don't have to pay it out at separation, thereby saving the company a lot of money? And my answer is maybe. I mean, that certainly does seem reasonable based on that language. If I know anything about the Illinois Department of Labor, that feels too easy. So more to come on that. But bottom line, let's all be prepared to review our PTO program for Illinois employees come the end of 2023 so that, in theory at least, an employee is not being given twice as much paid time off as they might otherwise be given. And then finally, the law does require employers to restore the PLFAW Act leave of employees who leave their employers but return to the same employer within 12 months. California also got into the party and expanded their California Family Rights Act leave. It expands on the categories of individuals for whom an employee may take leave to care for under the CFRA and under California's Healthy Workplaces, Healthy Families Act. Under the amended CFRA, an employee may take unpaid leave to care for a, quote, designated person, which is defined as any individual related by blood or whose association with the employee is the equivalent of a family relationship. Similarly, an employee may take paid leave to care for a, quote, designated person under the amended Healthy Workplace, Healthy Families Act, defined as a person identified by the employee at the time the employee requests paid sick days. Under both of these acts, an employee may identify a designated person at the time they request the leave. An employer, however, may limit an employee to one designated person per 12-month period. California also has a new bereavement leave. Under AB 1949, employers are required to offer employees up to 5 days of bereavement leave. Employees who have been employed for at least 30 days may take 5 days of bereavement leave for a family member, defined as a spouse, domestic partner, child, parent, parent-in-law, sibling, grandparent, or grandchild. Bereavement leave need not be taken consecutively, but it must be completed within 3 months of the death. Notably, the statute states that leave shall be taken pursuant to any existing bereavement leave policy of the employer. Therefore, employers have 3 options for compliance depending on their current practice. If no existing bereavement leave policy is being utilized by the employer, then the 5 days mandated by the new leave may be unpaid. If an existing policy provides for less than 5 days of paid bereavement leave, employees are entitled to take not less than a total of 5 days of leave, consisting of the number of paid days of leave available under the policy, with the remaining days to be unpaid. For example, a policy that provides for 2 paid days of bereavement leave would result in an employee taking 2 days of paid bereavement leave and 3 days of unpaid bereavement leave. And finally, if an existing policy provides them less than 5 days of unpaid leave of bereavement leave, employees are entitled to take not less than a total of 5 days of unpaid bereavement leave. In all situations, employees may use vacation, personal leave, sick leave, or other compensatory time off to substitute for unpaid leave. Interference with the leave or improperly denying the leave are unlawful employment actions. However, an employer is permitted to ask for proof of documentation of death within 30 days of the first day of leave. And with that, we are going to move into my potpourri of miscellaneous new laws of interest. First is the Federal Pump Act. I warned everyone that we are in our realm of acronyms, and the feds are no exception to this. So this is a federal act that was part of the Omnibus Spending Act. It is known as the Providing Urgent Maternal Protections for Nursing Mothers Act, i.e. the Pump Act. I will reserve comments about that. This new law expands the existing lactation accommodations for nursing mothers under the Fair Labor Standards Act. The FLSA was amended in 2010 to require employers to provide reasonable break time as needed and a private place other than a bathroom for nursing mothers to express breast milk for 1 year following a child's birth. This requirement, however, applied only to non-exempt employees. Employers with fewer than 50 employees were also not subject to this requirement if compliance would impose an undue hardship, determined by looking at the difficulty or expense of compliance in the context of the size, financial resources, nature, and structure of the particular employee's business. The Pump Act expands the breastfeeding accommodations to include exempt as well as non-exempt employees. It also specifies that the employee must be completely relieved from work, otherwise the time is counted as hours worked, which is relevant for non-exempt employees whose actual time worked must be tracked for purposes of calculating compensation and overtime. The new law maintains the exceptions for small employers for whom compliance would impose an undue hardship. There are new exceptions for certain employers of air and rail carriers, as well as motor coach service operators. The same guidelines as to payment for break time are carried over into this new law. However, there are new provisions related to the location. Employers have 10 days in which to come into compliance with the location requirements after an employee notifies them of their need for nursing breaks, and an employee can bring a lawsuit against the employer if it fails to do so. The 10-day period does not apply if the employee has been fired because they requested a nursing break or location or opposed an employer's conduct related to this requirement, or if the employer has stated that they will not provide an appropriate private location for the purpose of expressing breast milk. So the employers don't have that 10-day period if they've already engaged in some form of retaliation or bad act. Now I'm going to touch briefly on Illinois' Crown Act. Effective January 1 is a measure that amends the Illinois Human Rights Act to provide that the Illinois Human Rights Act definition of race includes traits associated with race, listing certain hairstyles such as braids, locks, and twists as an example. As such, the Illinois Human Rights Act now prevents discrimination on the basis of one's hairstyle if it is associated with an employee's race. Employers should be aware of this change and make sure that workplace dress codes or grooming policies are updated to comply. Next, I want to point out New Jersey's very recent change to its WARN Act. These changes will not take effect until April 10th of 2023. That's a 90-day period from when the amendment was enacted, which was January 10th of 2023. So they're giving everyone 90 days to get into compliance. The substantial changes to the WARN Act include timing of required advance notice before the employment action is taken under the New Jersey WARN Act. It's been increased from 60 days to 90 days. The amendments eliminate the distinction between part-time employees and full-time employees. making the New Jersey WARN Act applicable to all employers with 100 or more employees anywhere in the United States, as long as the employer has operated in New Jersey for more than 3 years, irrespective of tenure or hours worked. The New Jersey WARN amendments expanded the definition of establishment to incorporate all of the employer's New Jersey locations in operation for longer than 3 years, requiring employers to consider employment actions happening at all of their locations cumulatively within the state. The act is now applicable in all instances where 50 or more employees located anywhere in the state are terminated. For example, the calculation of 50 or more employees are not counted separately at different sites anymore. Even when proper notice is given, however, severance pay is automatic. Now, this is definitely a departure from the federal WARN Act. New Jersey WARN now requires employers to provide 1 week of severance pay for each year of completed service to employees impacted by an action protected under WARN. Importantly, employees may not waive their right to severance under New Jersey WARN without state or court approval. If an employer does not provide proper notice of layoff, the employer will now be required to pay each impacted employee an additional 4 weeks of severance pay. So you can sense that this can get really expensive really quickly. So we need to be very mindful of the New Jersey WARN Act amendments that go into effect in a couple of months if you have a fairly substantial but not overly substantial presence in New Jersey. The threshold is really quite low and as a result could impact a lot of us on this call. And then finally, I want to talk about the Illinois amendment to its 1-Day Rest in 7 Act. Effective January 1, these amendments require that employers give non-exempt employees 24 hours of rest in each consecutive 7-day period. So we're no longer talking about weeks in which we could get a little funny with the calculation. We now have to talk about consecutive 7-day periods. Employers can request permits from the Illinois Department of Labor authorizing the employer to require employees to work on designated days of rest based on business necessity and economic viability. We also can allow employers to ask their employees to voluntarily give up this day of rest. However, I would tread very lightly on that and make sure that we are writing this down and really getting it in documentation form. But the best course of action is certainly to get permission from the Department of Labor. The amendments also affect meal break requirements. Prior to January, employers had to provide non-exempt employees who work a 7.5-hour shift with a 20-minute meal break that occurred no later than 5 hours after the start of the shift. Beginning January 1, Illinois employers must now provide another 20-minute meal break for each additional 4.5-hour period that an employee works. In other words, an employee must be scheduled to work 15 hours to be eligible for that second meal period. So hopefully this isn't too much of an impact, but if you do have Illinois non-exempt employees who work 15 hours, we need to be mindful of this second meal period. The amendment increases penalties for violations up to $500 per offense for employers with 25 or more employees, and damages must be paid to affected employees with the same dollar amount ceiling per offense. So these can get really expensive really fast, so we really need to be cognizant of it. And finally, employers must also display the Your Rights Under Illinois Employment Law poster with these amendments starting at the start of the year. So if you haven't done it yet, it's only 18 days in, so hopefully you won't be in too much trouble, but certainly take the time today to post that poster. I'm going to move to the second secret word, and while you guys are all doing this, I do see we have one question that I will try to answer and use this time for that. So today's second secret word is act. Please select the correct word below. The question that we have are, do these wage laws apply if you recruit employees from those states? What if you have a current employee who moves into one of those states? Both great questions, and absolutely things that we're facing in light of the fact that people have moved a lot over the last couple years. The short answer is yes. If you have someone that moves to another state and is then subject to one of these laws and they're up for promotion, yes, we have to be giving them those same disclosures that we would anyone else who works in the state or is applying. If you recruit employees from those states, yes, we have to be cognizant of those wage laws. But even if you're not intentionally recruiting, but are posting the job, and then people from those states can see the job posting and apply to it, we better be in compliance. I'm stopping short of giving counsel to my clients to say that just as a matter of course, we should be posting pay ranges, but I think we're getting pretty darn close to that day as we see more and more states jumping on this bandwagon. And we have every reason to believe that the feds may get into that too, since without getting into a whole different tangent, we may have to comply with pay reporting depending on the size of your workforce to the federal government as well. So I hope that answers that question. It looks like everyone has submitted their secret word. So with that, I know we're right at the 12:50 or the 50-minute mark, but I'm happy to stay on if anyone has any other questions. I know I threw a lot at you in a very short period of time, so I'm sorry if people had other things that they wanted answered, but do not hesitate to reach out to me via email or phone. And as I said, we will keep monitoring all of these developments, and if we get more clarity on any of them, we will be sure to let you know. All right, seeing no questions, thank you all very much for attending, and we hope to see you back here next month with a whole new topic. Thanks and have a great day.